This is Bloomberg Law with June Grasso from Bloomberg Radio.
We have a Trump-hating judge. We have a judge who shouldn't be on this case. He's totally conflicted. But this is a trial that should never happen. We think we have a very conflicted, highly conflicted judge. He shouldn't be on the case, and he's rushing this trial, and he's doing as much as he can for the Democrats. This is a Biden-inspired witch hunt. It's a political witch hunt. It continues, and it continues forever. And we're not going to be given a fair trial. It's a very, very sad thing.
Donald Trump states his grievances about the hush money trial outside the Manhattan Criminal Court every day before trial and after trial. His complaints are basically the same, particularly about the trial judge, Juan Merchan. Trump has made motions to get the judge to recuse himself twice, to no avail. And Judge Merchan is moving things along, to Trump's apparent dismay. On day 2, 7 jurors were sworn in. They are an information technology worker, an English teacher, an oncology nurse, a sales professional, a software engineer, and, in a bit of a surprise, 2 lawyers. The trial is not in session on Wednesday, so voir dire or jury selection will resume tomorrow. 5 more jurors and 6 alternates must be selected before opening statements can begin. Joining me is Bloomberg legal reporter Patricia Hurtado, who is covering the trial. Patty, I know that hordes of reporters have descended on the courthouse. Set the scene for us.
There have been several hundred reporters that have come down to the courthouse in lower Manhattan. At least there's not the anarchy we had for Trump's arraignment last April. It's much more contained. Security is tight, but it's not like the phalanx or a wall of Secret Service agents guarding Trump. It's been very quiet and contained. Members of the media with a media lawyers coalition went to the court people to get it arranged. So you do have to go through 2 TSA-like screenings, and several hundred reporters are there. Some celebrity journalists and celebrity lawyers are there, including Kellyanne Conway's ex-husband, George Conway, has been spotted in the overflow courtroom. Access to Trump is limited because right now we're in jury selection, so the room in the courtroom can seat about 100. They've basically put in 96 people, prospective jurors, so only 6 pool reporters have been allowed in the actual courtroom with Donald Trump.
The judge started with close to 100 jurors on the first day, and half of them were dismissed. Just explain that process. There's
a 42-question questionnaire they have to answer. And right off the bat, the judge says, please let us know. You know about this case. Can you be fair and impartial?
So normally when jurors say they think they can't be fair and impartial, the judge does a little more questioning. But in this first round, he just let them go.
The judge basically had ruled. The defense wanted them all to be explored. Like, let's hear what everyone has to say, why they don't want to be on this case, right? And the judge decided that was going to be a waste of time. If people were being honest enough to say they couldn't be fair, that they would have to believe them and take them at face value. Trump's lawyers on Monday made an argument that they wanted to hear, and they made a motion over the weekend that they wanted to hear everything everyone had to say, possibly to drag out the proceedings, right? And the prosecutors basically accused the defense and Trump's team of just trying to collect evidence so they could have appeal issues.
Before the questioning of the individual prospective jurors begins, the lawyers make introductory statements. Did anything strike you about those statements?
Yes. And one of the things I was really struck with is one of the prosecutors is a longtime state brackets prosecutor, works in the Manhattan DA's office. His name is Josh Steinglass. He's really good. And he gave what was pretty amazing spiel that was like an opening argument. And he said something along the lines of, let's all admit this. This is a trial that's extraordinary. The defendant is a former president of the United States, current candidate running for re-election. Some of you may not have heard about this case and want to run out of the courtroom. Let's talk about basically the elephant in the room. And it was extraordinary, mini opening statement. He said, this case has all these unusual elements. You have a former president of the United States running for re-election, presumptive Republican nominee. The case involves testimony of a adult film actress and a lawyer who worked for Trump who has pled guilty. Well, let's all admit that this is extraordinary. And then went into, but let's explore this. Putting that aside, do you have opinions, negative about this or positive? It was pretty unusual, and I thought it was a really good window into what the prosecution is going to be like.
What was the basic tenor of the defense statement?
The defense statement was done by Todd Blanche, and he basically wanted to explore, do people have animus to Trump? And what do you think of Donald Trump? Do you like him? Do you really like him? Do you really, really like him? Or do you really dislike him? And it was all on, do you like him or not like him? And we had a very unusual person who was eventually struck last night. He's a resident of Harlem. He was friends with some of the Central Park 5 defendants and said that he knew their cousins too, and that he knew Donald Trump had taken out an ad some 30 years ago. And if people remember what Donald Trump did in the 1980s, I guess right around the time of the 1989 attack of the jogger. So this was a case where 5 young Black and Latino youths were charged with raping and brutally assaulting a white woman jogger in Central Park. And they were arrested and convicted by the Manhattan District Attorney's Office. And then they were eventually, that same DA, Robert Morgenthau, in 2002, said they were wrongfully convicted after a 9-month investigation. And they cleared them of all wrongdoing. But these kids had been in prison. And one of them is now a city councilman, Yusuf Salaam. So Trump, at the time, took out a full-page ad in many newspapers, including my old newspaper of Newsday, basically saying that this was an example of how they should reinstate the death penalty. And this guy remembered, and he started saying, well, Trump walks into a room and people pay attention. He also said he didn't read the newspapers because he didn't believe them. So eventually, guess who struck him? The
prosecution.
DA. Yep. Because it sounded like he might be a guy that may believe in conspiracies and also didn't want any information. Plus, if he knew that, if the DA's office had wrongfully convicted his friends and acquaintances, he may not feel too kindly to the DA.
On day one, in the afternoon, when it seemed to be moving at a glacial pace, there are reports that Trump sort of dozed off.
I was in the overflow courtroom, and I did not see that. But I did see him close his eyes and lean, lifting a little bit. Now, my father used to do that when he was elderly, and sometimes he was asleep. I don't know that I would say that definitively that he was asleep. I also saw at one moment where Trump was leaning over talking to Todd Blanche, and he kept talking while Blanche was trying to talk, and Blanche put his hand up like, okay, which is kind of extraordinary, but Trump was trying to get his ear when Blanche was trying to make an argument or talk to the prosecutor. So that's not something you see every day, but...
So did Trump's lawyers really dig into the social media posts of prospective jurors? I mean, going back years?
Yeah. In fact, there was one woman who was struck. There were postings of people celebrating when Joe Biden got elected. And she said that she felt it was akin to when people celebrated during COVID. Remember when we all went out to our stoops and our fire escapes and banged on pans to support the healthcare workers. Mm-hmm. That's what she said that this was akin to. It was a celebratory moment. And it was just New York, having its day. But she did say she was driving around honking, spreading the cheer. So the judge interviewed her and asked further questions and then decided that she wasn't necessarily being as forthcoming as she should have been. So when she said, I don't have an opinion about Trump, the judge felt that that showed that she had an animus towards Trump. Another woman that the defense struck was an older woman who had an image of Obama and Trump standing together. This was a Facebook post from back in 2017, and it said, "This isn't what I thought when they said orange is the new black," with Obama and Trump. And then it turned out that was her husband's social media post, but she had reposted it. So the DA was arguing there were lots of these things that the defense was trolling back in time and trying to go through everyone's social media account.
Judge Merchan, experienced judge, known for being no nonsense, even-tempered, but even he shouted at Trump on day two?
He was angry because they called this young woman in about the banging of the pans and the celebratory moment, right? And they called her back. And if you can imagine, this poor young woman is getting brought in and has to stand at the podium. She was 12 feet away from Trump. And she started answering the questions. And apparently Trump was muttering under his breath and gesticulating. And the judge heard it and called out Trump on it. And he told Blanche that he had to control his client. And he said he would not tolerate any jurors to be intimidated. So that's Trump being reprimanded by the judge and warned.
Coming up next on the Bloomberg Law Show, I'll continue this conversation with Bloomberg legal reporter Patricia Hurtado. Just how did two lawyers get on the jury? I'm June Grasso, and you're listening to Bloomberg. Donald Trump has pleaded not guilty to 34 felony counts of falsifying business records as part of an alleged effort to keep salacious and he says bogus stories about his sex life from emerging during his 2016 campaign. The Manhattan trial is being referred to as the hush money trial. The first 7 jurors were sworn in on Tuesday after lawyers grilled the jury pool about their social media posts, political views, and personal lives. There's already been one sort of dust-up in the court as Judge Juan Merchan admonished Trump after he spoke loudly and gestured while the judge was questioning a woman about a social media post. Merchan said, "I don't know what he was uttering, but it was audible, and he was gesturing, and he was speaking in the direction of the juror. I won't tolerate that. I will not tolerate any jurors being intimidated in this courtroom." For his part, Trump has complained about the judge every day, accusing him of being biased and rushing the trial, especially not allowing Trump to miss court one day next week so he can travel to D.C. for the Supreme Court oral arguments on the question of his presidential immunity.
And he's not going to allow us to go to that. He won't allow me to leave here for a half a day, go to D.C. and go before the United States Supreme Court because he thinks he's superior, I guess, to the Supreme Court.
I've been talking to Bloomberg legal reporter Patricia Hurtado, who's covering the trial. Pat, did some jurors just refuse to give their opinion of Trump?
I wouldn't say that. I would say that people would say, I don't have an opinion. That's a difference, right? You know, there were people who said, I don't have an opinion. I don't think any negative things. I just don't have an opinion. I don't think about him. And that might be disappointing to Trump that people just don't think about him. You know, one juror, potential juror, said, I know our country's future is resting right now on this, what's going to happen.
Jury selection seemed to be going so slowly, even Tuesday morning, with the judge just before lunch break expressing some frustration that it was taking too long. Then, bam, jurors were selected 1, 2, 3 in the afternoon. What happened to speed it up?
Everybody is expecting jury selection to be like in federal court. State court is very deliberative. It's really slow and plodding. I covered Harvey Weinstein's trial. It took 10 days to pick a jury. So that's the kind of thing that is very typical. The lawyers ask questions, they explore. The judge limited statements to half an hour for each side. And then what happened is, if you can imagine, so there were 96 potential jurors brought in, 50 excused themselves, leaving us with 46. And then they put 18 in the box, and they started asking them in the jury box what they thought. So that's what took a long time, because the individual jurors had to answer, have you ever followed any QAnon movement? Do you have any strong opinions or beliefs about the former president? Do you believe he shouldn't be criminally charged? 42 questions each person. So that's what was taking a long time. And then what ended up happening is after all those people were vetted, Trump couldn't put off the inevitable and couldn't delay it any longer, and they asked for more time. Trump's team asked for more time, and then they got a lunch break, And then they came back, but they had to exercise peremptory challenges and ask him to challenge for cause.
I just want to explain there are two kinds of challenges to a juror, for cause and peremptory. And for cause is what it sounds like. The attorney has what he or she thinks is a legitimate reason to excuse the juror. However, the judge has to agree. The other kind of challenge is peremptory, and that is for any reason except for reasons of race, sex, and the like. In this case, the prosecution and defense each have 10 peremptory challenges, and so far they've each used 6, leaving them with 4 peremptory challenges for the selection of 5 more jurors and 6 alternates. So, Patty, after this first group of jurors, they brought in a second group?
They brought in a second group of 96, and now they're going through those people, which they're going to have to get. They have 7 seated jurors, and they have to get 5 more to fill the box, and then they have to get at least 6 alternates.
Not 1, but 2 lawyers were seated. And usually neither side wants lawyers on the jury because they can insert their own legal opinions, and the jurors might turn to them for that. Is there anything you remember about the questioning of the 2 lawyers?
Well, both of them seem to do either business law or civil litigation. I definitely know juror number 7 is a white man, a civil litigator who doesn't know anything about criminal law. I don't know anything about election finance. To the degree that I know, I can put it aside. Do you think you should hold Trump to a higher standard? Answer no. What are your thoughts on Trump? Answer ambivalent. Some of the things I like, some of the things I don't. I'm not sure if I have any opinions about his character. I'm not sure I know anything about it. I'm a litigator, so I take the law seriously, and I will take the judge's instructions seriously. Another juror, who is number 3, apparently a young Asian male, says, I'm not actually super familiar with these charges or the other charges. I don't really follow the news that closely. I'm a little embarrassing to say. One juror, a middle-aged man, said, he's juror number 4, quote, I find him fascinating and mysterious. He walks into a room and sets people off. He's an IT consultant.
So the judge had set off 2 weeks for jury selection. Now, he asked the first 7 jurors to report to court as soon as Monday. Does that mean that there could be opening statements on Monday?
That's up in the air. He told the people that were sworn in as jurors to keep in touch, and they could come back Monday for opening, depending on how things go tomorrow and Friday. But if we all remember, Monday is the first day of Passover, and one of the members of the defense team is observant. So that might mean either a shortened day, or if someone on the panel is observant, then it would be no trial on Monday. So all of it's up in the air. Yes, opening statements could happen on Monday, but it's really unclear. We have to wait and see what transpires tomorrow and Friday.
So now let's talk about some of the motions before jury selection started. So prosecutors asked the judge to fine Trump $3,000 for 3 social media posts.
That was the first thing that the prosecution did on Monday, which is one of the reasons why jury selection was so slow. The entire morning session, instead of picking a jury, was all on pre-trial motions and asking for clarification from Judge Mershon on his prior rulings, like, for example, should the Access Hollywood tape, can it be played or can it at least be quoted from? So what the prosecution asked for is they felt that recent postings by Donald Trump, including over the weekend, were in violation of the judge's gag order from April 1st. And they're asking for Trump to be sanctioned for the 3 postings and to be found in contempt of court. They also cited that posting that apparently the prosecutor said had been posted from the courthouse Monday as a 4th example, but they weren't including that in their hopper of, in their basket of misbehavior by Trump. And they wanted him to be fined $1,000 for each of the 3 earlier social media postings. And they also wanted Trump to be warned that if he continues to violate this, gag order that he could be jailed. So the judge is going to have a hearing and schedule that for Tuesday.
The prosecutor, in his statement to the jury, said that some witnesses have some edge, and he described them as a tabloid publisher, an adult film star, and Trump's former lawyer, Michael Cohen, was convicted of federal crimes. Michael Cohen is going to be the star witness, and there have been arguments about his testimony already.
There were discussions about how much the limiting of the defense and how much they can go after him. The judge had basically said that it's fair game to raise the arguments about, his guilty plea, but he didn't want to make it a mini trial of the federal case against Michael Cohen and make it like Michael Cohen's trial rather than Donald Trump's trial. So they can raise the background issue of Michael Cohen pleading guilty, but they can't have a mini trial by the defense to basically reopen and relitigate what Michael Cohen pled guilty in federal court.
Trump wanted to be off to campaign, in quotes, on Wednesdays, and he also wanted to be excused next week so he could attend the arguments before the Supreme Court on his presidential immunities.
The judge was very stern with him about that because his obligation, he said, is you have an obligation in this court, not that court, and you're on trial here. I mean, it was almost like he said, you don't belong in that Supreme Court, you belong in Manhattan Supreme Court, where you're on trial, and he wasn't going to excuse him. He also was complaining and asked Todd Blanche, Trump's lead defense lawyer, that his son is graduating from school, I believe. He had a graduation to attend to, and so does Mr. Trump, for Barron Trump. And the judge said, well, we'll cross that bridge when we get to it, but that's in May. One of the funnier episodes that happened during jury selection, one of the potential jurors was a woman who said her friend was getting married in September, and if she was picked for the jury, would that be a problem? I mean, everyone roared with laughter, and the judge said, if this trial is still going on in September, we'll all have a problem, basically.
At least he can still show a sense of humor in the face of all this. It's going to be interesting to see whether they can finish the jury selection this week and get started sometime next week. Thanks so much, Pat. That's Patricia Hurtado, Bloomberg legal reporter. Coming up next on the Bloomberg Law Show, we're going to be talking about a controversial spy law that the House has reauthorized. Will the Senate do the same? I'm June Grasso, and you're listening to Bloomberg.
On this vote, the yeas are 273, the nays are 147.
It's in the hands of the Senate now. The House of Representatives voted to reauthorize a key part of the Foreign Intelligence Surveillance Act on Friday. The measure allows the federal government to eavesdrop without a warrant on foreigners in overseas investigations. The FBI director warned of dire consequences if it's not renewed, but its critics were an unusual mix of right-wing Republicans and Democrats focused on civil liberties, both concerned that it sweeps up the data of Americans. Here's Republican Representative Jim Jordan of Ohio and Democratic Representative Jerry Nadler of New York.
If they don't fall in the exceptions and they're searching Americans, searching your name, your phone number, your email address in this giant database, that should scare us. And if it's a small number, then what's the big deal?
Officials are supposed to find it reasonably likely that a query will turn up evidence of a crime or foreign intelligence information. But that did not stop them from searching for protesters, politicians, and political donors, to name a few, without proper predicate.
Joining me is Matthew Waxman, a professor at Columbia Law School and former senior official at the State Department, the Department of Defense, and the National Security Council. Tell us about Section 702.
Sure. So the main FISA statute, the Foreign Intelligence Surveillance Act, goes back to the late 1970s. But we're talking here about Section 702, which was part of a major modernization of that statute in the 2000s. And what it allows the government to do is to collect on U.S. soil and with various oversight checks the electronic communications of targeted foreigners abroad, even when those targeted foreigners are communicating with Americans. And so to do so, the law authorizes the government to order service providers think telecom companies or Google, to hand over copies of messages or calls to or from those targeted foreigners abroad.
And is the controversial part of this bill the part where, in circumstances where Americans are in contact with a foreign surveillance target, it sweeps up the data of Americans? Is that why it's controversial?
That's right. So the statute itself authorizes the government to target foreigners abroad. But some of those calls or emails from those targeted foreigners abroad are going to be with Americans or people here in the United States. And those communications that get swept up are often referred to as incidental collection. The idea being that the Americans are not the ones being targeted, it's the foreigners abroad, but oftentimes there are going to be some communications with Americans that are collected as well. And the biggest controversy is about the FBI's access to those incidentally collected communications with Americans.
It sort of was an unlikely coalition of lawmakers, far right wing of the Republican Party and Democrats focused on civil liberties, who were trying to change the law, a major change. They wanted to have a warrant requirement.
As you say, there's a coalition of some strange bedfellows who are pushing in Congress for a major reform to Section 702. I say a coalition of strange bedfellows in that it was members from both the far right and the far left. For so long, debates about FISA in Congress were usually between what I might call the civil libertarian left and the more hawkish right, as well as a lot of members in the center. But we've seen the politics of surveillance really shift. And to the question of what kind of reform the advocates were pushing for, I think the most controversial one was to add a warrant requirement, the idea being that every time the FBI might want to go into that set of incidentally collected communications with Americans, in order to, the word is query that database, to look for certain communications within that previously collected set, the government, the FBI, would need to go to a court for a warrant and make a certain showing in order to then get court permission to do that specific query.
And is getting a warrant so burdensome for the FBI?
I think some reforms were necessary because there were some problems with how the FBI was using the Section 702 data. But I think a warrant requirement would have gone or would go too far. I think that for a couple of reasons. First, we're not talking about authorizing surveillance here. The surveillance has already been authorized and done. And what we're talking about here is the ability of the FBI, under certain narrow circumstances, to look at that information that's already in the government's files. In addition, the FBI has already adopted a number of reforms itself since some of the problems with 702 were exposed. But beyond that, I think a warrant requirement would go too far. Warrants are, by design, very burdensome and can take time, whereas national security threats move quickly, especially in cyberspace. And we're also, when it comes to foreign intelligence or national security, we're often talking about trying to piece together information, intelligence, in order to determine whether, for example, an individual, there's probable cause to believe that an individual is engaged in certain types of nefarious conduct. And the last point I would just say on this is many of the FBI's queries of the 702 database are related to cybersecurity, especially combating foreign threats like ransomware gangs or foreign government agencies that are engaged in cyber attacks. And the FBI needs to move quickly. It may need to run a lot of queries in order to combat those attacks.
That warrant requirement didn't pass in the House. It was a tie vote, but Section 702 did.
That's right. So the House has reauthorized Section 702 with a few reforms, not the big controversial one, which was the warrant requirement, but with some reforms. And the House reauthorized the basic 702 authority for 2 years. The cycle had been every 5 years, but as a compromise in the House, it was just a 2-year reauthorization. Now the action switches to the Senate to see whether the Senate will pass an identical or very similar bill. My best guess is that the Senate will maybe even just pass the House's bill, and we'll be in a situation where this gets wrapped up quickly and sent on to the president for signature.
So Senator Ron Wyden, a Democrat from Oregon, said, "This bill represents one of the most dramatic and terrifying expansions of government surveillance authority in history. I'll do everything in my power to stop it from passing in the Senate."
I think that's a gross exaggeration. I think we are talking about a very powerful intelligence tool, but because it's so powerful, there were from the beginning a number of checks that were built into the system. Those checks have been improved over time for good reason. I mean, look, the FBI was sloppy with this tool. Reforms were necessary, but a lot of those reforms were already taken within the executive branch. These were things like reducing which FBI officials have access to the database, stronger reporting requirements, stronger penalties for violating those rules. These were sensible reforms and needed reforms. And the House bill and what I think will likely pass the Senate will codify in law some of these reforms. I think the warrant requirement goes too far, and I think Senator Wyden is underplaying the intelligence imperative behind this tool and exaggerating the dangers of it.
Can I ask you, there was a letter to House and Senate leaders where the Department of Justice confirmed that the administration on March 5th submitted certifications to the FISA court that, if approved, would authorize Section 702 until April of 2025.
So one of the questions throughout this reauthorization process is exactly when is the true deadline? When does the program actually cease to work? And there's been some shifting in that timeline as the executive branch, in anticipation of possible expiration of the statutory authority, has looked at what are some orders that we could seek from the Foreign Intelligence Surveillance Court that would extend beyond April 2024, when the statutory authority is set to expire. When might we be able to get an order that would apply beyond the statutory expiration? And there is some good reason to believe that the executive branch could get some orders that extend beyond the deadline next week. I think one of the problems for the executive branch is that those orders would be on much weaker legal ground, much more susceptible to challenge without reauthorization of the statute. So they're absolutely right to push for quick reauthorization, and Congress is right to think about the end of this week as the true deadline.
Let's say Congress reauthorizes it. Then is that the end of it, or is the FISA court still going to go ahead?
So then the FISA court would still be charged with examining the government's new request for an order. The big difference after Congress passes this bill, as I hope they do, is the statutory authority would be extended for another 2 years. As I mentioned before, the previous pattern had been that the statute would be authorized for 5 years before it would sunset. This would give the congressional overseers more of an opportunity to examine how effectively was the system working and how effectively were the checks operating. And the original request from the executive branch was that Congress reauthorize it for another 5 years. One of the compromises in the House was to keep 702 pretty much the same, but only extend its authorization for another 2 years this time, so Congress would get another bite at this within 2 years.
Thanks so much. That's Professor Matthew Waxman of Columbia Law School. And that's it for this edition of the Bloomberg Law Podcast. Remember, you can always get the latest legal news by subscribing and listening to the show on Apple Podcasts, Spotify, and at Bloomberg.com/podcast/law. I'm June Grasso, and this is Bloomberg.